Good morning. Welcome back. I hope you're having a wonderful day. We're following up from yesterday's webinar on child custody and child maintenance. We are taking live questions from you on the Advocate Mohammed Abduroaf Facebook page. Take a minute to get yourself ready. This webinar should start in a few moments' time. I'm just giving everyone an opportunity to join us. We have published the webinar for 9:30 a.m. There was a change in times. I trust we all received the notification on time. I'm just sharing it to relevant pages. Please note, if you have a question, you need to post it onto the Advocate Mohammed Abduroaf Facebook page. That's where the live stream is originating from. I think we're all set. Let us begin. Again, a good morning to all of you who are joining us on today's Facebook Live Q&A on the topic of child custody and child maintenance. We're following up from yesterday's webinar that took place early morning, whereby you could have posted live questions. I have a comment. Yes, good morning. Thank you for that. And someone from the Northwest, all welcome to join us. As mentioned early on, you all are welcome to pose live questions, and I'm hoping to go straight into that. Therefore, if you have a question regarding child custody or child maintenance, the other party is refusing you contact to your minor child, or there are difficulties in relation to the exercising of your parental rights and responsibilities in relation to your minor child. Alternatively, if there is an issue regarding child maintenance, feel free to pose your question. Another good morning. Thank you very much for joining us. It's always nice to know who is joining us, and please mention, if you do not want to pose a question, feel free to say hi or to post where you are streaming from or viewing this video from. It is a live video. It does get posted onto YouTube later on, and it will remain on Facebook for some time. If you are watching this video but not live, it will be senseless to pose any questions. However, if you are watching it live now, feel free to pose whatever questions. We are still in the midst of the lockdown. Things are different. I had a webinar yesterday with an attorney, and we discussed these issues, and it was clear that in 2020 last year, parents got used to the idea of lockdown, and contact arrangements had to be amended. The specific contact arrangements that were in place prior to the lockdown, whereby maybe it's stipulated that the minor child will spend half the school holidays with one parent and the other half with the other parent. Contact will change on Christmas Day. Doesn't apply now because school holidays are much longer, and it got extended now recently for another 2 weeks or longer. Therefore, things are totally different than they were before the lockdown. And therefore, with that, the challenges are different. Regarding child maintenance, things are more expensive. Kids eat more while they're at home. They use more water, they use more electricity, they use more data, whatever the case may be, whatever your circumstances are. They may want to visit friends more often. They may want to phone friends more often. Whatever the case may be, the expenses are much more. If they are at school, obviously, they can run up the school's bill with the toilet bill and the electricity bill and so on. But if they are at home all the time, things are different. It might not be, sometimes it's cheaper. There might be other changes. For example, your transport bills are a bit less because you are not traveling that much. So it varies. However, each family is different. I have a question. I have a live question from someone. I'll answer it now. All is looking in order. The question goes as follows. Last year, I only saw my son for only 6 days due to COVID-19. We live in different provinces. Do I have a right to catch up on lost time? The principle of catching up on lost time doesn't really apply if there is a court order by default. So if there's a court order in place stipulating that you should have contact X, Y, and Z, and you do not have contact in terms of that court order, it's not for the parties now to, if they can on their own agree upon it, wonderful, but it's not for one party to say, okay, I want to now catch up by now having more contact at that specific date, and the other party must automatically agree there too. It is unfortunate. Therefore, when these type of things do happen, the parties need to go to a mediator or facilitator to resolve it. Practical and reasonable parents would take note of the fact that contact was limited during the lockdown and due to the COVID-19 pandemic, and allow a parent to make up that specific lost time, because the person or the individuals that loses out under these circumstances are the minor children. The minor child wants to have contact with the dad. He could not have contact with the dad because of the lockdown. They live in different provinces. We all know for the first few months, interprovincial traveling was not allowed, and the parents has to be reasonable. However, on the flip side, for me to stipulate that automatically you have a legal right to or request, and the request must be abided by, I need to have more time with my minor children, despite an order stipulating you only allowed to have contact on that specific period of time, is very difficult for me to say. I cannot say that because there's an order in place. The order might say the father can have contact every June holidays for the second half, but he was not allowed to travel to Cape Town or to Johannesburg during the second half of the June holidays because of the government's regulations. For the parties now to swing the order to allow a deviation of the order can be problematic on both sides, because the mother might have made an arrangement for the kids might have to be in school, the kids might have certain other plans planned for the balance of the period whereby they should not be in the other parent's care or contact. So it's very unfortunate that parents cannot agree upon it. My advice to the specific person is stick to the court order, and if the other party does not want to allow you additional contact for no good reason, then I would strongly advise you to approach the court, and the court can relook the whole issue, and the court can amend the contact and care arrangement. For the sole reason, as I mentioned early on, contact and care is a right of the minor child, not necessarily the right of the parents. Yes, parents need to see the minor kids as well, but if it is not in the minor child's best interest to have contact with a relevant parent, that specific contact should not happen. I hope I answered the question. I must just be very cautious, because if I had to now say, yes, catch-up is allowed, when will catch-up take place? During school term, parties are living in different provinces. So I'm being very cautious in that answer. I'm certain if you want to add additional questions to that, I might be able to elaborate further, depending upon the age of the minor children, how far the provinces are apart, are the parents working, are the kids attending homeschool, are they, we all know they're at home now, but the facts will vary. In order for me to give a proper answer, I need to know more facts. Thank you for that question, and you are welcome to pose any further questions. If you are watching this video, please leave a comment and say from where you're from, and it's always good to see regular faces online. If I may just add further, okay, the person poses additional information. Let's just deal with that first before we move on. The additional information, sorry, it's a different person. I have another question. unmarried father who does not have visitation rights and is behind on maintenance and always has excuses, not working, can't afford, or in debt. That's what the person is saying. So he's behind in maintenance, always has excuses, blah blah blah, and he is in arrears. Child is a non-verbal special needs child. Yesterday, he brought my son to court as he was visiting him. Court and his lawyer was not happy. Now my case is postponed till March. And when I ask him to go buy food for our son, he threatens me with the welfare. Can you advise? I do not follow the stream so well, but be that as it may, this is a typical example where parents cannot come to an agreement regarding what's in the best interest of the minor child. One parent might not be much involved in the minor child, and I'm presuming it's generally a scenario where the parties themselves have issues, and that is very unfortunate. My experience under these type of matters are that the moment parents have issues, they can't communicate with each other, they have difficulties with the manner in which the other parent is caring for the child, difficulties in the manner in which the other parents are dedicated to the well-being of the child, and so on. These type of issues keeps bringing problems to the situation. Like now, when the person said over here, child is a non-verbal special need child, which is very important to note. Yesterday, he brought my son to court as he was visiting him. Court and his lawyer was not happy. Now my case is postponed. I do not see the logic behind bringing a child to court. It's COVID-19, and why would the child come to court in the first place? There's no reason for it unless the court requests the child to come to court, either for an assessment or for some consultation with a court official or the social worker and so on. So these are serious issues over here. And with the mother mentioned here that I ask him to go buy food for our son, he threatens me with welfare. Can you advise? Now, the relationship between a mother and father is obviously toxic, and I'm not, this is only facts here, it might not be correct, I'm not referring to anybody. I was given a set of facts, a set of questions, and I need to apply my mind to that. It's clearly toxic. It seems to me on all fronts, when it comes to the parenting of the minor child, specifically stipulates over here, the person starts with a sentence, unmarried father who does not have visitation rights and behind on maintenance. But later on in the paragraph, he said the father brought the minor child to the children's court or to the relevant court over there. But be that as it may, the relationship between the mother and father is clearly toxic. These type of matters will always be there. They will always have these type of problems. So my strong advice to these specific persons are, have this court litigation finalized as soon as possible. Get an order in place. If the order says that the father can have contact X, Y, and Z, and that's it. Or it says he cannot have contact, whatever the case may be. If the maintenance order stipulates that the father should pay 100 Rand or 200 Rand, have it finalized. If tomorrow the father can afford more money, and you believe he can, then you approach a maintenance court again. But the more the parents communicate with each other, and the more the parents start dealing with each other, especially under these circumstances, where the mother asks for maintenance and then the father threatens to take the child to welfare. I would imagine maybe to social services. I do not know what that specific means. It could also mean maybe apply for SASSA grant, could be anything. But be that as it may, unless these specific parents figure out a way to communicate with each other civilly and responsibly and so on, the minor child will always be in the middle, and the minor child will always be affected by how these specific parents respond and deal with these situations. So my advice to the specific person is, I do not have this one-step advice to fix these type of problems, or do this or do that. I would most probably have advised you at the start, go to the children's court or go to the maintenance court, but you are there. My advice is, finalize those issues and come to a resolution as soon as possible. Okay, the question regarding the interprovincial traveling, an additional comment. He says, thank you. You are welcome. And he lives in George. Yeah, so George is quite far away. And I strongly believe that the parents need to come to some type of a resolution. And with COVID-19 being indefinite, there will have to be a change in the manner in which parenting plans and consent papers are drafted going forward. Consent papers and parenting plans, settlement agreements, dealing with the minor children, of course, in the past presumed that school holidays will always take place June, July, December, January. I'm talking about the bigger holidays. And of course, Easter and other holidays as well. Now with this pandemic, we see it more often that holiday contract is not always set in stone. School holidays are no longer the same duration they were in the past. And they swap and change, they change all the time. The only advantage I can see for me is traffic is much better to work, which I appreciate. But kids are at home and they should be at school. They should be learning to become professionals in the future. But be that as it may, parenting plans, consent papers, and settlement agreements regarding to minor children, clauses will have to be created to deal with these specific issues, the pandemics. Therefore, in additional response to the question posed early on from regarding the interprovincial contact taking place, in the future the courts might have to put in clauses, for example, say if there is a pandemic and if the minor child is not possible for the parent to have contact with the minor child, then under those circumstances contact should be extended by the time lost. Those specific clauses will have to be created. It was not previously stipulated generally in consent papers because things were usually set in stone. The minor child is in primary school now and next year will be in high school. The minor child is in daycare now, but in a few years' time he or she will be attending school. So those things were basically set in stone, but now we do not know how the future will unfold. A lot of questions are coming in. Thank you very much for that. The maintenance issue, the person commented further, says, X makes everything about me. No request was made. X is very abusive to me. I give him access as I want peace. This is my advice to anyone. If another person is abusive towards you, committing domestic violence, emotional abuse, psychological abuse, whatever the case may be, I strongly advise that you enforce your rights and you obtain a protection order. A protection order, approach a domestic violence court in your area. If there has been abuse in the past or domestic violence in the past, you'll get a protection order, and the protection order will basically say that he or she is not allowed to commit the psychological or emotional abuse. And if he or she does do that again, you go to the police station, the courts will provide you, on a successful application, with a warrant of arrest, and the police will arrest this person for a violation of the protection order. Something to consider, something to look up. There's many articles on the internet dealing with protection orders. It's concerning, and it's a reality that when spouses meet each other, things are fine, they have a child, and life is good. When they separate, things become toxic. Not all situations, but when it does become toxic, people have one mission. It is to make life hard for the other party, or the mission might just be, only to not listen to the other party and be one-track mind, only focus on what's best for them and what will work for them. That's very sad. And if that is the situation, I always advise people go to mediation, go to facilitation, speak to a parenting counselor or childcare counselor, someone that deals with these type of matters, who can speak to the mother and the father. Mother can speak and say, I have the following problems with the dad. These are the issues I have. I've been having these issues for the last year or two. He doesn't want to listen. Fine. But he's in the room, so he's listening to her. He never listened to her for the last 5 years. And then he'll speak as well, and he'll give his response for why he's responding that way, why he's doing that, what problems he has with the mother. And then she will have a chance to reply, and so on, depending upon how the facilitator or the social worker or mediator decides to deal with this matter. The parties will now come to a conclusion, and they will most probably leave that meeting or that session at least with some additional data on their hard drives. Where previously it was only there while you're thinking, but now they actually listen to the other party's reasoning and logic. And the other party can say, when the child is here, the child is angry, the child is, depressed, anxious, and so on. The other party initially might be angry, because how can you say that the child is not angry and depressed when he's with me? But she said it. Initially, his response or her response might be a bit not what we'd want it to be, but he or she will go home and it will settle down and he will start pondering on that. So dialogue is extremely important. The person comments further and says, I have tried to be peaceful, but he constantly attacks me. I would say a protection order. If you have any questions, please feel free to pose it. I do not mind speaking for a long time, for the entire 40 minutes, but it is always beneficial to you to pose your questions and have someone answer it, and we can engage with each other. I'm just figuring out, yes, the person that commented earlier on regarding the interprovincial contact rights, wanting to know, can there be any catch-up contact rights? He has an additional comment. He says, if maintenance is increased and all of a sudden life quality is increased of the mother, he is done for over 1,000, etc., what can I do? Regarding that, if you are paying maintenance, maintenance is payable for the minor child or minor kids, depending upon the facts. Maintenance is not there to support the other parent. If you are supporting the other parent, it would usually be in terms of alimony, in terms of a personal maintenance clause in a divorce agreement, and so on. Then you have a legal obligation to maintain the other parent, pay your alimony, pay your personal maintenance. But if there is no such agreement in place or no such order in place, there is no obligation for you to maintain another adult. The only time you have to maintain another adult if you are married to that person or in terms of an order and so on. Therefore, if a party is increasing the payment of maintenance, that specific maintenance has to go to the minor child. If it is not going to the minor child, obviously there needs to be a reduction. If the mother is increasing her lifestyle, there could be many reasons for that. One reason could be she's earning more money, she got some money this time, she inherited money, whatever the case may be. The calculation in determining what amount of maintenance you should pay is based upon 3 factors. Firstly, the cost of the minor child. That's important. What are the reasonable costs of the minor child? That's a base from which we work. If the minor child only costs 100 Rand a month, you cannot claim 200 Rand a month. That doesn't make logical sense. If the minor child costs 50 Rand a month, but both parents earn 50 Rand per month, that's a problem. We have to lower the minor child's expenditure. If the minor child costs 100 Rand a month, the father earns 1,000 Rand a month and the mother earns 2,000 Rand a month. Clearly, the mother should pay 2/3 of the minor child's expenditure and the father should pay 1/3. So the mother pays 63 Rand or 67 Rand and the father will pay 33 Rand. That's a basis upon which we decide maintenance. The needs of the minor child, the means and expenditure of the mother and the means and expenditure of the father. Now, when we determine means, we have to look at various aspects. Someone may be unemployed, but he or she has a pension fund, he or she has property, gold coins, assets laying somewhere. So he has means, or she has means, although he or she does not have any income. Therefore, when determining a fair amount of maintenance a party should contribute to his or her child, we do not only look at the income, we look at the means. Because it will be a bit unfair if the mother, in this example, in my example at least, has to use all her money to maintain this minor child, and the father earns much more money, and he uses a lot of his money for investment purposes and is developing himself, and the proportion upon which they worked it out was based upon income only, but the father is a multi-millionaire, he earns properties, etc. So it's important to determine the maintenance amount based upon the minor child's needs, the means and expenditure of the parents, and so on. Going back to the question, I cannot comment as to whether or not the mother upping her lifestyle is reasonable or not. If the mother has increased her income, things will have to be re-looked at. So when the maintenance agreement or the maintenance order was made, the mother earned X and the father earned X, and the father had to pay X. I'm presuming the father has to pay. Now the mother's income has increased drastically, or means has increased drastically. Clearly, there needs to be a recalculation whereby the father would have to pay much less. My advice to the specific person is, you need to determine, is the mother using the money which you pay towards a minor child, or is she supplementing, that's the word, supplementing her lifestyle with the maintenance you are paying. Alternatively, she may be paying or using that maintenance which you are paying towards a minor child, but your contribution which you are paying is far too high based upon the means of the mother. In other words, she's earning much more than you, she has much more assets than you, she should be paying more towards a minor child than you. Something to consider, something to look at. It's only 2 sentences. I cannot conclude specifically in saying this applies to your scenario. I'm giving general advice, and it might apply to you, or you can use that to take it further. The question regarding early on the maintenance issue, where the parties are embroiled in some type of misunderstandings, and the father is emotionally and psychologically abusing the mother, the person says, thank you, you are welcome. If there are any other questions, please feel free to post it. I'll be happy to answer it. Yes, we're heading for half an hour. These videos are usually 40 minutes or so. And if you have any additional questions, wherever you are, please feel free to post it. I'll be happy to answer it. And as mentioned earlier on, please pose a question from the, you can see over here, Advocate Muhammad Abduroaf Facebook page. Go on Facebook, type in Advocate Muhammad Abduroaf, and you should be able to find the page. If not, that's the URL for the page. And that's where I'm looking at all the time and waiting for questions to come in. The format of these webinars is not to mention the law. We all know the law. You can download the Maintenance Act. You can read the Maintenance Act, and there's the law. You can look at the Constitution. You can download the Children's Act, and that's the law. The idea behind these webinars is to explain to you basically on how the law works, the practical aspects thereof. It gives the viewer and the listener a much better understanding of how to resolve a legal problem. It's like if somebody is sick and I give him a medical textbook, that won't fix the problem. I need to, medicate him. I need to do what I have to do in order to make him feel better. And the same way with these webinars are to unpack and to explain to you on how to deal with your specific maintenance or child custody matters. While I'm waiting for questions to come in, please note that, like the Advocate Muhammad Abduroaf page, notifications of webinars are now posted there on. If there is a change in times, you will see it online, so you can just go online all the time. Alternatively, You might see it on your Facebook profile. On the issue concerning child maintenance, and this, I'm just following up on this webinar I had with this attorney yesterday. We touched a bit on child maintenance, and her view, and I agree with her, as an attorney, it's up to the parties to buy in, and they need to make an effort for their maintenance case. Me as an advocate, as a litigator, someone that appears in court, I do not generally deal with clients filling documentation, finding documentation, and so on. That's generally attorney's work. But I have said it previously in my webinars quite a few times that you need to take ownership of your case. Yes, the other party is not paying child maintenance. Yes, the other party is emotionally and psychologically abusing you. You can have the victim approach. Unfortunately, I'm being very cold here, and hope people will still feel sorry for you, and hope that the world will change and you will get the results you want. Unfortunately, that's not how the legal system works. The legal system is quite cold, very analog, very logical, and there's no room for emotions. If you go to court, so the same principle applies. And also with the maintenance courts, they're quite busy, they're understaffed. You only one of the thousands of cases that are before them. You're just another person coming to them. And if they have to deal with 100 cases per day, you only have 5 or 6 minutes for argument's sake. I'm just exaggerating here. Therefore, in any legal matter you are dealing with, being a child custody, child maintenance, a traffic fine, you need to take ownership of your case. You need to do the relevant, work in order for you to get your results. Yes, you can appoint an attorney, you can appoint an advocate. He or she will do what he or she has to do to get you the best results. However, it's very much dependent upon you. The same with losing weight. You can have the best personal trainer. If you're not willing to put in the effort of eating well and exercising regularly, you will not get the results you want, no matter how good your personal trainer is. The same with the law. Therefore, when you apply for child maintenance at the maintenance court, prepare your documents. Highlight the relevant documentation. Make the photocopies. Don't let your attorney do all those type of things. Why can't you do that? Go to the maintenance court and find the application. Stand in a queue. Why must you pay a lawyer to do that if you can do that? That's all that I have to say now. We have another question that came in. Thank you for that. It goes as follows. My kid's father is no longer interested in being in her life. I haven't asked him for financial assistance ever. He has last given me in 2019. Is he liable to assist me with medical aid and school fees, etc.? Bearing in mind he doesn't support financially at all and doesn't choose to see her. I would presume, and the person can tell me if I'm right or wrong, that there is no maintenance order in place and the parties have some type of informal understanding or arrangement which seems not to be working. But if there is a maintenance order in place, please comment upon that and I can change my answer. But I will answer now based upon the assumption there is no maintenance order in place. So it starts with the following. My kid's father is no longer interested in being in her life. That is very unfortunate and very sad, because this child would like to know I have a father. I see my father regularly. My mom and my dad are no longer together, but I still have a dad, and he might have remarried, he might have moved on with his life, but there is a dad in the picture. I see him once a week, once a month, whatever the case may be. But I find it a bit, disconcerting that a father does not want to be in his or her child's life. There could be many reasons for that. I do not know. Maybe the couple themselves have certain issues, and if he might feel that because I have issues with the other parent, whenever I want to have contact with a minor child, I have to engage with that parent. That could be one reason, but I don't think that's a valid reason. I mean, you need to go beyond that. People are in court all the time fighting for their rights to see the minor kids, despite the issues involved. So that's not a very good reason, but that could be the reason. Alternatively, he or she is apathetic and does not want to see the other child. I think that's very selfish, and I feel very sorry for that child, and I pity the parent that is like that. The person commented further, my facts are correct, there is no maintenance order in place. So the parent goes further, or the person goes further and says, I haven't asked him for financial assistance ever. He has last given in 2019, so that's about almost 2 years ago, depending upon when. Is he liable to assist with medical aid and school fees, etc.? Yes, he is liable to assist. He is a biological father. He is even liable towards you for maintenance since the party separated, or since the last time previously, when he last supported a minor child, or when last you lived together, and so on. In terms of the Maintenance Act, you can claim from birth. But be that as it may, you are entitled to claim from him cost for medical expenditure, school fees, and so on. And the person goes further and says, bearing in mind he doesn't support financially at all and doesn't choose to see her. My advice to the specific person who made this comment would be approach a maintenance court as soon as possible. Many parents are apprehensive. They hear from friends or from family, you won't get what you're entitled to in a maintenance court. It's a waste of time. I do not think so. I would say, yes, under certain circumstances, things can be a waste of time because the other party does not have any money. The other party is unable to, to support a minor child, whatever the case may be. It's like me telling you, don't apply for a job ever, because when you apply for a job, you will not get a job. Because all my friends, they applied for jobs and they never got jobs. That's not good logic. Yes, you apply. Sometimes the results are good, sometimes the results are bad. But at some point, you should get the results. Millions of people have jobs. Okay, so moving on. You need to approach the maintenance court as soon as possible. The maintenance court would call him in. They will call you in. They will inquire into the matter. You will obviously explain to the maintenance court how much the minor child costs, come with the documentation, receipts, proof of expenditure, working out very well that the child eats so much, the electricity, water, etc. And there's many webinars and videos online dealing with that and how to calculate the child maintenance. Just Google it. And you will come prepared, and he will say, this is a father, and I have information regarding that. He used to work here, he used to work there. I went on Facebook, and I see he has a very good social profile. I have spoken to his family, and they told me the following. Okay, that might be hearsay. These are the places he last worked at, and I spoke to him, and he's been earning so much money. Do a bit of research. I'm just being general here. I mean, I do not know all the facts. I need to sit down with this file and be creative and get some, creative juices out there to find out how to deal with such a matter. But be that as it may, go to the maintenance courts. Let the maintenance courts deal with him. And the more effort you put into your case, the better the results. The specific person provided some additional information. I've never kept him away from her. He is remarried for the past 5 years. He has been in and out of her life. So I presume the parties were married before when she says remarried. He stays away and comes back like nothing happens. I'm 100% certain he will come back. I'm just scared that he will cause us psychological issues in the end. You see, this is the reason why I suggest parents, the moment they start having these type of issues, these parental issues, you need to legalize and formalize things. In the sense of getting a parenting plan in place, getting some type of an agreement in place so that you know that I will only have to see this person X, Y, and Z. I cannot unfortunately change people's personality. The specific father, that is his personality. He might be a wonderful person outside, but when it comes to his family and when it comes to his ex-wife, there are issues involved. It could be because he remarried, his new wife, he has new kids, and this is a previous relationship, whatever the facts may be. However, the psychological harm which a minor child suffers, well, of course, it's bad. Therefore, we need to take stock of these type of matters. If he's not paying maintenance, go to the maintenance court, because maybe the mother's view is, and I'm speaking general, I'm not saying specifically this specific person, could be, if I claim maintenance from him, then he wants to be in a child's life, so let me not do that. But at the same time, it's a problem because we need the maintenance. Furthermore, we have no contact agreement in place. We need to formalize these things. If parties were not married civilly, civil marriage are simple. If you marry somebody in court, you get divorced, you get divorced. The court will deal with the parental rights and responsibilities. If people are in a relationship or married in terms of Muslim rights and so on, there is no divorce court dealing with these type of things, contact and care rights and child maintenance. Therefore, I strongly urge this person to formalize the arrangements. If he should see the child once a year on special days, then that's it. Then you know he cannot come on the other days. And you can control and deal with your life. When he gets called into the courtroom, or before the magistrate or the officer, depending upon the situation, he will have to explain, what does he want? Does he want to have contact? When does he want to have contact? And so on. The conversation will take place. But the two people who are the worst to have this conversation together would be the mother and the father, because they cannot see eye to eye. It's clear. If they could see eye to eye, we would not have had this discussion. Therefore, I'm not specifically answering, or my facts might be totally incorrect. I'm not judging anybody based upon 2 paragraphs. I might be totally off, I might be totally wrong, and I apologize for that. I'm just taking information and I'm giving a general answer. It might apply to the commenter, it might apply to you watching this webinar from wherever you are and whenever you're watching it. Please, my advice to you is formalize matters, finalize matters. I don't know how old the child is. The child might be 10, 15 or 13. Whatever the case may be, formalize it, go to the maintenance court, get the maintenance order in place. Go to the children's court and formalize the contact and care arrangements. At least you will know he cannot pop up anytime. He can only pop up in terms of this agreement. And if it does not pop up is a bad term, but if he does not exercise his visitation rights in terms of the parenting plan or the order made by the court, and then you approach the court again, tell the court this is nonsense. He does not adhere to the court order, therefore take that clause out and find out by him when does he want to have contact. Maybe once a year now, or he can only have contact once a year, but he needs to check with the mother at least 3 months in advance, or 2 months in advance, or 2 weeks in advance. I don't know, whatever's fair and reasonable. You'll have to argue it before the magistrate, or the person said to do. So I hope I answered, or I dealt with that specific question reasonably, so that it makes sense. But at the same time, the viewer and someone else, I hope you understand what I said and can benefit from that. If you have any additional questions, I can still go for another 8 to 10 minutes. It's now 42 minutes we are live. Please feel free to pose the question, and I will try my best to answer it. If you have any additional points to add to the previous questions, I'll be happy to deal with that. So going back to my discussion I had earlier on with you regarding a maintenance matter, in any matter, take ownership of that. I like it when a client comes to my office and tells me, yes, Mr. Abduroaf, I have child custody issues. I have prepared a historical data, or typed out this history of my matter. I have on paper when I met the other party, how things were then, when we entered into a relationship, for example, either marriage, or when we started dating, or when we started moving in together. I have outlined when the problems started happening then, when the child was born, who was at the birth, what were the complications involved, and so on. And I have that on data. So before you even go to a lawyer, you need to take stock of your case. Yes, of course, you can consult with a lawyer, obviously, for advice at any time. But I would strongly advise someone, if you do take stock of your case, you have these things in place. Why should you first sit with an attorney or an advocate, and then the attorney advocate takes notes? Okay, ma'am, when were you married? What were the problems? And bill you thousands of rands for the time spent. Yes, if it's urgent and those are the facts, then wonderful. Life must go on and we need to deal with what we have to. But if you are having problems with the other party and you foresee the possibility of these issues going to court one day, take pen and paper, go on your PC, go on your computer, archive this data in a very secure folder, create another account that nobody knows of, so that your spouse or your partner will never see it, and start typing. If you are a victim of domestic violence, I know this is not the topic to discuss today, but if you are a victim of domestic violence and something happens, type it out. If you took photographs, if it's a once-off thing, it happened now, okay, it happened, but take photographs of the damages that was suffered and archive it and file it somewhere. It may come in useful in a few years' time. If there are any episodes of your partner attacking you or acting irrationally or acting irresponsibly towards a minor child, it might not be a big thing. It might just be a once-off thing, and it could have been, spurred on by some other things. The child was naughty, the child dyed his or her hair red, shaved their head. I mean, I do the same, but you're following what I'm saying. And the one parent acts, but wildly viciously. Yes, maybe that's reasonable. I don't know. I know corporal punishment is not allowed, but take notes thereof. Take a photograph. I don't know. Archive it somewhere. It may be useful in the future. You might not even need it, but you may make your life very much easier going forward. So start with that dossier. Start typing. The commenter early on said one more comment. We're welcome to get more. Can I request for sole custody if he's currently not in the life, in the child's life? Yes, you can. You can request that, and you have to prove that that will be in a minor child's best interest. So basically, what you will ask for, you'll ask the court to confirm that you are the primary caregiver of the minor child, and maybe you say, for example, that the father can only have contact with the minor child, supervise, and if you want to allow it. I'm just generalizing. It's a general question. Yes, you can. Whether or not you'll be successful or not, that's up to the court. How you term your documentation, how you term your request will obviously be based upon your consultation with your attorney, your advocate, and they will now decide based upon all these facts. This is most probably the best possible result we can get based upon these facts. So obviously, if the mom and dad were married and they were living together, the child always still saw the parent all the time, and that's the situation. The parties separated, the father remarried, and the mother doesn't like it. She's jealous because of the father. She cannot say, I want to get sole custody. She will never get that. It will never happen. It won't happen. She might ask, I want to get sole guardianship, even harder to obtain. So those things are out of the table. But if a client comes to my office and says the other party was never involved in the child's life, never saw the child, now and again pops out of nowhere, the child calls my new spouse daddy and so on. But I would like to have something formalized for this person to only have contact when I allow it, or with due notice, based upon the fact that this person keeps on threatening me to take me to court and to social welfare and so on. Then you could possibly bring up a case for that. And regarding guardianship, whenever I apply for the minor child to go to school, or I go to the hospital, they keep on asking me, where's the father? Because on the birth certificate, both parents' names are there. Then under those circumstances, yes, it makes sense, apply for sole guardianship, because why must you always look for this father that's never in the child's life? I think that's it. If there's anything else, if I see anything else popping up, please pop it up as soon as possible onto the comment section. We have 17 comments. Thank you very much for that. And we will be online this afternoon again at 4 o'clock with some other professional people dealing with child custody issues and so on. An organization called Dads Indeed. I'll be speaking to them, and there are a few webinars happening tomorrow, quite a few. I have one with an attorney the afternoon, and I have one with a psychologist also, I think, the morning. It will all be posted on our Advocate Muhammad Abduroaf page. Please like that page for updates or visit the page regularly. As I mentioned earlier on, all live questions and answers takes place on the Advocate Muhammad Abduroaf page. I can only keep an eye on one page. The webinars are, of course, cross-streamed to various other pages as well. Thank you very much. Have a lovely day, and hope to see you online soon. And thank you very much for those persons who have posed those questions. It's greatly appreciated.